Hey, everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. Sorry, I'm late. This is one of the fast recaps that I'm now doing of the latest filings, which you guys know I go over in full at night when they drop. And we're going to keep this one to 15 minutes or less, so it's nothing too crazy. But last night, this motion came out as only 22 pages, and a lot of that was just contents type stuff, so it wasn't like anything crazy. How did I get jelly on my arm? We're not going to talk about that. Sorry, so like wasn't anything crazy. But I also went over it with my lawyer friend Omar, the Tilted Lawyer, who comes on this channel quite often. So before I start skimming over the actual filing with you, let me tell you what he had to say about it and what his legal opinion of the filing was. I think this part of the stream, and which I'll also post a link to in the comments when this stream is over. I think this about sums it up for him from his perspective. So give me one sec. There we go.
Ryan Reynolds might have been more behind the original 12v6, but this really looks like a paralegal got some. They told some paralegal, "Hey, do some research to oppose this motion," and they probably jumped on ChatGPT or whatever and try to come up with something. But it's so. I don't think they fact checked it. They didn't check their cases. The law is just flat out wrong in 80% of it. There's some cogent arguments here and there, but it's a pile of hot garbage. I graded a D.
All right. So that was the lawyer's review of it. Anyways, here's what we're working with. 1 second. There we go. So this was a reply in support of the motion to dismiss. What happens is somebody submits their motion or their complaint. Then if somebody wants to put a motion to dismiss, like Ryan Reynolds did, they do that. Then Wayfarer responded to that. I can't remember now, even if it was last week or the week before. I think it was last week. And then the other party can then respond to that with support, like they just did here, before the judge will then say, oh, it's fully briefed and we can rule on it. You don't have to file one of these. I did not know that because I'm still learning. But apparently Omar says he all the time will just, if he thinks it's not a good idea to file one, then he won't file one. So keep in mind, they did not have to put this out there, but they did. Okay. And there's lots of speculation on why they may have done that. So I'll let the Ask Two lawyers, I'm sure they're going to go over this stuff and they'll answer that because they obviously have a more comprehensive understanding of all these things than I do because I am not a lawyer. All right. So we're just going to skim through this. We're not going to read too much. I would tell you it's a lot less scathing and dramatic than the other one. The other one was very showboaty in my opinion. And this one is just kind of it falls pretty flat. There was no there was not really much snark in it at all. So it was kind of well, in a way that's good and in a way that's bad because it's oh, good, it's an actual legal filing, and in the other way, it's oh no, because I kind of preferred to read the other one. It was more entertaining, but that's not how court works. So let's see. Introduction. The Wayfarer Party's opposition confirms the central thesis of Mr. Reynolds' motion to dismiss. The FAC is a meritless list of grievances and hurt feelings designed to retaliate against Blake Lively for raising sexual harassment and retaliation claims. So, right, this same tired old line, pretty much, which is it's nothing new, and it's kind of meh. Again, like I said, it falls a little flat. 1 sec. I have to pull up a part of last night's stream for you guys that made me laugh this morning. So I'm just gonna get that ready. Hang on. Okay, we're not gonna do that yet. Anyways, so they just basically throughout this filing, they're a Wayfarer didn't do this. Wayfarer didn't do this, and the fact is, yes, they did that. They did do that. So, as one example, despite the FAC's preposterous $400 million damages claim, the opposition concedes that the FAC, in fact, alleges no actual monetary harm whatsoever, instead relying exclusively on a defamation per se theory that, even if it were valid, which it is not, fails to allege cognizable claims or cognizable damages for any of the FAC's other claims. Huh? That's not, somebody missed the mark. Okay. And then here we see it says disregarding their Rule 11 obligations, every Wayfarer party asserted each claim against Mr. Reynolds, meaning that every Wayfarer party other than Mr. Baldoni brought a federal lawsuit alleging at least one cause of action that they know they had no legal basis to assert. None of Mr. Sarowitz, Ms. Nathan, Ms. Abel, It Ends With Us movie, or TAG, the agency group, has a single cause of action against Mr. Reynolds that they even arguably possess. All of those claims should be dismissed, and Mr. Reynolds should be awarded his attorney's fees and costs under applicable New York law. All right. So this is where they start getting into stuff like they failed a state of defamation claim, and then they're basically just repeating themselves down here. And Omar was basically saying, like, what are you talking about? Like, that's not even remotely accurate. The Wayfair parties concede that the only statements of Mr. Reynolds alleged in their first amended complaint were the predator statements, which the first amendment, the FAC claims were uttered in New York. And the FAC expressly alleges that the Wayfair parties' injuries were experienced in New York. Even if some portion of the alleged injury occurred elsewhere, where the alleged conduct and alleged injury take place in different jurisdiction, it's the place of the allegedly wrongful conduct that generally has superior interest in protecting the reasonable expectations of the parties who relied upon the laws of that place to govern their primary conduct, and in the admonitory effort that applying its law will have on similar conduct in the future. Okay. Fails to adequately identify any defamatory statements. So again, this is where it kind of gets stupid, where it's like, what are you even talking about? Right? Mr. Reynolds' statements are not of and concerning 6 of the 7 Wayfair parties, which is kind of what they said above. The predator statements are unactionable opinion, which we've been over. Let's see. Instead, the FAC's allegation of Mr. Reynolds' purported disdain for Mr. Baldoni demonstrates that his impassioned comments were likely to be opinion, not fact. No. The opposition confirms the conclusion that the alleged defamatory statements are substantially true, which is just the most... Oh my god. Okay. The Wayfair parties claim that the court cannot conclude as a matter of law that Baldoni is a sexual predator. Okay. But the substantial truth doctrine does not require the court to make any such determination. Instead, dismissal is warranted where, as here, the allegedly false statements, they are false statements, would not have a different effect on the mind of the reader from that which pleaded truth would have produced. The Wayfair parties do not address the case's holding, and therefore concede that the court can take judicial notice of Mr. Baldoni's public statements and otherwise offer no basis for the court to conclude that those statements, i.e. the pleaded truth, would have a different impact on a listener than the allegedly false ones. For example, that Mr. Baldoni acted in a predatory manner. Likewise, to the extent the court finds that the Wayfair parties otherwise sufficiently alleged some unidentified statements to the New York Times and unnamed third parties, there would be no different effect on the reader between Mr. Baldoni's own statements and those unspecified statements. Oh boy. The FAC fails to allege actual malice. Okay. They argue that Mr. Reynolds got hold of communications between Wayfair from Stephanie Jones that disproved the claim that the Wayfair parties had orchestrated a smear campaign. But that claim is nonsensical. For starters, the FAC does not allege anywhere that Mr. Reynolds had access to any such materials at the time his alleged statements were made. That's worse. You get that? You get why that's worse, right? Okay. In any event, the conclusory assertion that those materials disproved any smear campaign is directly contradicted by the communications. Although the Wayfair parties argue that Mr. Reynolds' actual malice is established by the inherent improbability of an untraceable campaign, they have admitted to just such a campaign in their own words. That is the dumbest... I'm not going to say those words. Move on. Thus, the only reasonable conclusion is that Mr. Reynolds would have believed in the existence of a smear campaign. Help. I'm sorry. The FAC, I'm sorry, that's just so stupid. The FAC fails to state a false light claim. Then we have the civil extortion claim and tortious interference claims must be dismissed as to Mr. Reynolds. The civil extortion claim must be dismissed. Let's say the Wayfair parties assert that California law applies to the civil extortion claim, but despite conceding that the choice of law analysis is conducted separately for each individual claim, they do not analyze choice of law with respect to the civil extortion claim, resting solely on authorities limited to the defamation context. Even under California law, the claim for civil extortion warrants dismissal. The Wayfarer parties assert that Mr. Reynolds points to no authority that California courts limit the claim, but fail to address Mr. Reynolds' discussion of Furman v. California satellite systems. All right. Regardless, Wayfarer also declines to defend their allegations of civil extortion as compliant with Rule 9b, as they must be to survive dismissal. What planet are we living on? All right. The tortious interference claims must be dismissed. There's a lot of psychobabble here. The FAC fails to allege conspiracy liability. The Wayfarer parties do not dispute that all of their conspiracy allegations are made on information and belief, or that such allegations are insufficient to allege conspiracy liability. Instead, they simply assert that they have pleaded ample allegations in connection with each cause of action against Reynolds to support the existence of a conspiracy at the pleading stage. But they mention only one such allegation, namely that Reynolds and Lively made a joint threat to attack the Wayfarer parties in the press. Okay. Paraphrasing paragraphs in the FAC that allege the Wayfarer parties were informed and presumably believe that Mr. Reynolds and Ms. Lively had requested a public apology for misconduct on the set of the film. Okay. That was not a request. To be clear, that was not a request for a public apology. It was sign this document no matter what or else. Mr. Reynolds is entitled to attorney's fees, which I don't even want to entertain what bullshit that is. Leave to amend should be denied. So they obviously they don't want the judge to give them a chance to write a second amended complaint, right? Because that's just going to be even worse for them. Can you still send audio clips? Yes, please do. Please do. And I'll put the email right here in the chat real quick. All right. So before we go, I want to show you my this part of the stream from last night that somebody pointed out to me. It's just a few seconds, but it's I can't believe this happened because I know what's going on from my point of view, right? But I don't usually watch my streams back. Like I don't want to watch myself talk. So I don't usually see these things from you guys' perspective. So just this was just something kind of ridiculous. So somebody sent me this timestamp and was like, did you just let one go on stream? And I was like, what are you talking about? Hang on. Into the reader from that which the pleaded truth would have produced. Okay. Ooh, my bad. My bad. Dude, that was not a fart. That was not a fart, guys. I swear, I was just dragging the cup by accident across the desk. And somebody pointed out that this morning in the comments, so thank you to the person who brought that to my attention. But just for good measure, one more time here. Reader from that which the pleaded truth would have produced. Okay. Ooh, my bad. My bad. It does seem like I just ripped one. Oh my god. That's so ridiculous. I smelt it from Texas. Dude, no. If I own my farts, man. That was not a fart. I swear to God. All right. Thanks, everybody. I got to get back to my work day. So I'll have some more updates for you. If not today, then tomorrow. But you'll know as soon as they come out because I'll be here. So thanks, everyone. Bye.